Court, John Duggan on behalf of Legato, LLC. Unambiguous, fully integrated, specific easements which contain commonly used phrases such as more or less to describe the area of the easement to 1/100th of an acre are not blanket easements or subject to what a reasonable person believes the easement is. In this case, we have a fully integrated, unambiguous easement that describes, by meets and bounds legal description, a very specific geographic location on the face of the planet Earth. They are oblong shapes. As a result, they do not come in rounded numbers such as 2 acres, 3 acres, 4 acres, because they're oblong. They are in a geographic area which is measured to a 1/100th of an acre, more or less, which is very common in commercial real estate. What occurred here was my clients alleged that there was water, silt, and mud that was going beyond the boundaries of the easement, and there was mud and silt that was within the boundaries of the easement, which were all violations of the easement agreement. My client was party to a rezoning effort because they were across the street from the Woodbury project, and they got notice and attended meetings where their property was described as a future wetlands, a discharge area for the Mentum project that Woodbury was proposing on the land owned by GOC. My clients objected throughout the public hearing process and learned after the public hearing process that there had been a stormwater plan that had been approved by the city as part of the rezoning that planned to discharge water from this new development onto my client's property outside the boundaries of the easement in a 100-year flood event to the nature of about 7 acres. My clients believed that that was an unlawful taking under the Kansas Supreme Court's decision in Ventures, which we cited in our brief, 225 Can 698, where the Kansas Supreme Court made very clear that in an approval process, if the city requires a property owner to dedicate 300 feet of their property for a future highway, that would be an unlawful taking that requires compensation. In this case, my client's plight was even worse than the party in Ventures, because my client wasn't even asking for their property to be rezoned. It was their neighbor across the street that was planning to rezone their property, that had no plans to hold their own stormwater on their own site and planned to discharge that stormwater onto my client's property, causing 7 acres of my client's property to be used for the stormwater discharge area in a 100-year flood event. A black letter law regulatory taking under Ventures under Kansas law. My client sued. My client said, "You're discharging mud and water and silt beyond the boundaries. You're discharging mud and silt within the boundaries. All are violations. And you've passed a zoning ordinance and approved a plan to discharge water as part of that zoning onto my property, which is an illegal taking." We went to Judge Moriarty and we said, "I think if you would look at the easement, it's unambiguous, it's got an integration clause, it is a specific easement grant with a specific meets and bounds. The city has no authority to discharge water beyond those boundaries." The city disagreed. They argued that the words more or less meant they could discharge where necessary on our property because the words more meant more than the legal description that was set forth in the very specific meets and bounds description. Judge Moriarty generally agreed with us, but tried to strike a middle ground between the parties and added a reasonable person standard to an unambiguous, fully integrated contract. And that is a one-off and would be the first time in Kansas where that would happen, and we believe that would result in a slippery slope for all legal descriptions in the state that are followed by the words more or less to generally describe the area, that a party would come in and say, well, it meant more. It didn't mean what it said. And we've appealed that because my client, it's very important in this matter as it proceeds forward that my client have it determined that there's no reasonable person standard, that it is what it says, and it means what it says. It's a meets and bounds legal description.
Counsel, I have a question.
Yeah, Judge.
All right, so you're focused on the 18 or 17.91 acres more or less. So it looks to me that you have raised 13 issues in this appeal. And number 11, you dismissed before the district court. So that leaves us with 12 pending issues. Aren't most of the issues that you're raising now either moot or not ripe because the development with Mintum has been withdrawn?
I disagree, Judge, for this reason. The zoning ordinance has never been officially withdrawn by the city of Olathe.
But it's never been published, so there's no effect for it.
Well, we believe the case law supports the conclusion that it doesn't have to be published. It's been acted upon, and the city staff advised the city council at the public hearing that if they wanted to revoke it without publishing it, they needed to pass a resolution to revoke it. But if this court enters an opinion that says the city cannot ever publish that, because right now it's out there with no termination date on it, it could be published tomorrow. And that was our contention with Judge Moriarty. If the city is saying crystal clear that zoning ordinance is dead, then just enter a judgment on our behalf on the deck action that says the zoning ordinance is invalid and void, and that part of the case is over. But they've never agreed to that. To suggest in a newspaper article that the current person that wants to develop it, which is not GOC, is Mintum, an out-of-town developer, doesn't plan to go forward with that development, in no way negates the zoning ordinance or its efficacy if they wanted to publish it tomorrow. So it's not.
Isn't that a separate issue? If they choose, should they choose to publish it, wouldn't you then file an action to stop that or to stop the enactment?
You've already filed an action to stop it based upon the public hearing that is the prerequisite to passing the zoning ordinance. And we believe the case law is very clear that your time period to appeal is from when that public vote occurs, particularly if they're going to postpone publication. And Judge Hauber wrote an opinion in Johnson County to that effect. So I said, what would you do if you were my client? Would you sit back and run the risk of not filing the suit to invalidate the zoning ordinance because they say we may publish it or we may not publish it in the future? Or do you go forward on an ambiguity in the statute and you file a lawsuit to say, well, it's invalid on its face? But just as importantly, Judge Schroeder, they've never done anything publicly, sent us a letter, made a statement, done anything to say that the preliminary stormwater plan or the final stormwater plan that says they're, as part of the rezoning, going to discharge onto my client's property has ever been withdrawn. But it's not moot for this other reason. We have allegations that there's current physical invasion of our property by mud and silt beyond the boundaries. That is an unlawful taking, which is moot.
Just a second, but didn't Judge Moriarty say that issue was reserved as a fact question that was undetermined?
No, he did not. He dismissed our unlawful taking case for inverse condemnation and said, I just don't see that there's a fact issue in this case, even though the lawyers stood up in open court. We block quoted it on page 28 of our brief and said there is a fact issue as to whether or not mud and water and silt is going beyond the boundaries of the easement. On its face, there were no 141 compliant facts ever submitted to Judge Moriarty upon which he could reach the conclusion that there was or was not a factual dispute on the mud going outside the boundaries of the easement. But the verified petition was very clear. It had photographic verified evidence that showed there was mud and silt going beyond the boundaries of the rock walls, mud and silt inside the boundaries of the easement, all of which is a pollutant under the Federal Clean Water Act, and all of which is going to require an EPA permit to clean up. Those are all allegations of a present, current day damage caused by the city's unlawful taking of our property to discharge their debris onto our property, which is a physical invasion. And we argued that to Judge Moriarty. The fact of the matter is, Judge, even if the city, as they seemingly say they would like to have you believe, has withdrawn all these regulatory approvals, we still have a temporary taking because you can't pass regulations and tie our property up in regulatory limbo for 2 years and go to court and argue you can flood us anywhere and then say, well, now I guess we lost that question because the specific easement is what it is and it's not we can flood you anywhere. Instead, now we're going to withdraw it. Well, we lost contracts. We had people that were negotiating our property that backed away because they didn't have any understanding about what kind of stormwater issues were related to our property because the city was standing up in open court saying we can flood you wherever we need to because of the more or less language in the contract. So it's not moot for all those reasons: physical invasion, regulatory taking, temporary taking, and the fact that there's never been any official act by the city to ever withdraw the zoning ordinance, the preliminary stormwater plan, or the final stormwater plan. The other issue in this case is...
Aren't those plans that the city's put in place specific to the development of Mintum and they couldn't be transferred without a reanalysis?
I don't know that, Judge. That's probably a question for an engineer, but the fact is that that zoning plan is tied to the plan that's in place to build a hockey arena for the city, to build a apartment complex around there. And so the zoning ordinance, which is tied to the plan and the zoning ordinance don't go away. The preliminary stormwater plan and the final stormwater plan don't go away. But again, Judge, you're asking fact questions that were never briefed to Judge Moriarty. There's no 141 facts that ever said, well, here's where all this occurs in this circumstance. All we had was a statement of counsel at a hearing that said, well, Judge, now that you've ruled against us on the boundaries of the easement, we're working on changing the stormwater plans as we speak. Well, I appreciate the counsel saying that in an open hearing, but that doesn't do anything to moot the fact that there is an approved plan that's never been formally withdrawn by any formal city action that we're aware of and have been made aware of in this lawsuit. So I still maintain the question's not moot, but keep in mind this question. They asked Judge Moriarty to rule that it was moot at the trial court level. He didn't grant that motion. They asked for that relief on the briefing. They've never cross-appealed that ruling to say he erred in reaching the conclusion that they should have won on the mootness issue based simply on a newspaper article that the developer was withdrawing from the plan. The property owner, GOC, still has an approved zoning that could be published tomorrow. I think that probably consumes my time on direct. I'll reserve the balance of my time for my rebuttal. Thank you so much.
Any other questions?
Not at this time.
Okay. Thank you very much, Mr. Duggan. We're ready to hear from City of Olathe, Ms. Greathouse.
Thank you, Your Honor. May it please the court. My name is Leslie Greathouse. I am counsel for the City of Olathe and for Beth Wright, its city engineer. I'm also speaking on behalf of the other defendant appellees, Great Olathe Center, a local developer and landowner who does still want to be able to do something productive with this land, although that will not include the Mintum project or that hockey arena. And Woodbury Corporation, a Utah real estate developer who entered into the now defunct contract to purchase the property. This case is about a development that's not happening. It's about a thing that is not going to be a thing. But it is also about what are currently two fields. Both of those fields contain stormwater infrastructure, and this is a regional stormwater detention system that serve the whole local watershed that moves water from the south to the north through the property. And in order to assist the court as you're considering this case, I would suggest that you look at the maps that are in the record at record 10, pages 5 and 24. They may help you understand the movement of things as you move forward. So the Great Olathe underground substructures collect, move, and pass stormwater onto the stormwater detention ponds on Legato's property. The regional stormwater detention system on Legato's land is above ground, and it's a series of ponds that were originally intended as a design feature back at the time that they were looking at building a regional mall on both the Great Olathe and the current Legato properties. At one point in time, those properties were both owned by Legato. These aren't static farm ponds. These are ponds and channels designed and engineered. So as water enters them, they rise and then they move over to the next pond through the channels. And so they're engineered to move water across the Legato property and away from the property on the northern end. We ask that you rule for the appellees for 2 reasons. First of all, great swaths of this case are moot, as Judge Schroeder pointed out. Mentum is not being built on the property. The property has not been rezoned. There is no additional or existing new stormwater plan that's going to impact the appellant's property. To the extent that some of those issues are part of Legato too, because one thing that hasn't been said yet today is that Legato filed a second lawsuit against these same parties with many of the same causes of action and also with some additional causes of action. And that's very important because much of what has been argued here today is actually at issue in Legato 2, not in Legato 1. And we need to be very clear in the record about what is part of 1 and what is part of 2. But speaking to the rezoning issue that was raised, it is correct that the rezoning ordinance has not been published. But what was left out is that the rezoning ordinance will only be published if the land is sold by Great Olathe to Woodbury. That sale is not going to happen. That contract has fallen through. So there's no way to issue or publish the rezoning ordinance.
Okay, explain that. So tomorrow, Great Olathe could decide to sell it to Woodbury and the ordinance could be published.
If they were to decide to do that, you are correct. But right now, there is no contract for the sale, and the star bonds that were being issued to, make this particular development economically viable are no longer available.
So if Legato's concerned that you could do this in the matter of a day and then ask for publication of the ordinance, why doesn't the city just formally withdraw the ordinance and then reissue a new one at some point in the future when you have a new developer?
Oh, we could certainly do that. This is the first time that that's ever been suggested. So that hasn't been a discussion that has ever happened. It's not in the record below. It's not in the briefing. No one has ever suggested that we should withdraw the rezoning ordinance. That's certainly something that I'm sure the city would consider.
All right, so wasn't the Legato land previously burdened with the water from the Great Mall when it was in existence?
Yes, it was. So the way that worked, Legato owned a whole series of property in that area, and you'll be able to see this on those maps that I referenced to you. They came up with a plan to build a regional mall, and the part of the land that is currently Legato was going to have ponds on it and a small golf course and some other buildings. And then they were going to build a regional mall where the Great Mall ended up. Ultimately, they didn't do that version of the development. They sold the property to the developers of the Great Mall, and it turned into the Great Mall. Then there were a variety of lawsuits that went on. These easements were entered. There was a settlement agreement. There was an easement agreement. And then when the mall was built, there were a series of other stormwater easements that went into place so that water could be moved not only from the Great Mall, but also from the Olathe Regional Medical Center. That all moves through the Great Mall, through Legato, and to the north.
All right, so then as I read Judge Moriarty's decision, he said there was a fact question left as to whether or not the city was properly maintaining the ponds.
The parties and the court agreed that that cause of action would not be addressed on the motions for summary judgment. So that issue, which is cause of action 8 in the first amended petition, has been reserved for Legato and the city to litigate another day. So the entire issues about the mud and the silt and all of that, that's been preserved. That is still to be decided in a separate issue. It was not decided here. And so to the extent all of that has been brought up, it wasn't decided below. It's not briefed in the court, in this court, and it wasn't briefed below.
So would you be opposed to entering an order being entered that the current zoning ordinances are withdrawn by the city?
I'm not sitting here with my clients today, so I certainly could speak to them, and I would be happy to get back to the court about whether or not they would be willing to enter into that. But I hope you understand, since we're Zoomed, I don't have them here to refer to today.
I just have a difficulty with all of this litigation going on, and it's an issue about something that the city doesn't plan to go forward with. But the Legato folks, they can't be sure what the city's going to do.
I agree, Your Honor. I can tell you that right now they're not going to do anything. I mean, we don't control the sale of the property. That is correct. But at this point in time, the city has no intention of rezoning anything. And the other thing that ties into this are those stormwater plans. So you were correct when you asked the question about whether those stormwater plans were specific to the Mentum project. First of all, the preliminary stormwater plan was never approved by the city. The way stormwater works is that the developer puts together a preliminary plan and submits it to the city. They then have, and it's conceptual, they then have a meeting with the planning part of the city, or not the planning part of the city, sorry. And they have a particular set of issues that they talk about in these stormwater meetings. And then a final stormwater plan is actually approved by the city. So, and the part of the city that actually addresses stormwater is Public Works, and the entity that approves, or the person that approves stormwater plans, is not the Planning Commission, but is the city engineer, who is the additional defendant here. So, and the final stormwater plan that was issued here, because it was issued before the building plans and the building permits were pulled, and very, very early in the process, the letter that transmits that final approval says, we reserve the right to revise this as necessary as the project moves along. So even a final stormwater plan is not final until the building permits are pulled. So moving along, we would ask that you rule for the appellees for 2 reasons. Not only is it moot, but in addition, the district court's procedure of including the 3 questions of law, applying the parties' undisputed material facts, and entering a journal entry of judgment was proper. So here, where the judge took this sort of sua sponte procedure, he did so with the stated goal of encouraging the productive use of this land. His goal was to have this project go forward so the star bonds could be issued, so that the parties were not going to lose the opportunity to develop these fields sitting in the middle of Olathe because of litigation that was brought. Ultimately, that ended up happening because we couldn't make the thing move fast enough. So after the briefing, the district court held that the appellees had no rights under the subject easement to use the ponds for the stormwater detention system on Legato's property outside the 17.91 acres, more or less. All I will say about that is that we all know that if there are words in an agreement, they mean something. More or less means something. Legato has not offered to you today any meaning for those words. Legato's argument is those words mean nothing. And so, in fact, what Judge Moriarty said is that they do matter, and they matter because this is not a matter of perfection. Now, that's not exactly what the defendants argued, but that's okay. The defendants were willing to live with that particular ruling. But perhaps the most important
you do
thing,
agree that it's a specific easement for
Yes.
water discharge to cover 17.91 acres.
yes, and we never argued that it was a blanket easement. If you look in the record, nowhere in the record do we argue there was a blanket
Right.
easement.
So I mean, I understand the term more or less, because when you get to describing by meets and bounds, it's hard to be specific, but this document is to 1/100th of an acre.
Yes, and I understand, Your Honor, the easement agreement and those documents, and I encourage you, to look at those actual documents. They do talk about the fact that this pond system is decided to freeboard, is planned to freeboard. So the water does rise, and it has to rise in order to move over the structure to cause it to move. So the water goes up and down in the ponds. It has to. It's the only way the water moves. So, and the district court fully understood that when they made the decision.
And I understand that, but that movement, wasn't it designed for that movement to stay within the 17.91 acres?
Yes. But right, yes, I agree with that.
So why would the city want to exceed the 17.91 acres?
We do not. And in fact, the final stormwater plan specifically says that in order to build on the Great Olathe Center property, the developer has to confirm that no water will go over the Legato land more than has already been approved. So there can be no increase in water moving off of that property. In closing, the rule we are defending today carries out the manifest purpose of summary judgment motions: to avoid delay when there is no real issue of fact. The rule is that district courts are authorized to hear issues on summary judgment sua sponte. Here, in compliance with Rule 60-256, the district court addressed part of the claims, determined what material facts were not genuinely at issue, examined the pleadings, and issued an order specifying what facts and claims for relief are not genuinely at issue. The rule proposed by the appellants would require that the parties be allowed to rely on facts not included in their summary judgment motion to overturn a resulting judgment. And what is really important here is the fact that Legato 1 does not assert a current taking. A current taking only came up after the district court ruled on summary judgment. The issues were, or the timeline is very important for you all to look at here. So the judge announces the sua sponte procedure. We brief it. There's an oral argument. He rules from the bench. He then retires. The parties enter into quite a debate about what the journal entry is going to look like. It took an additional 4 hearings, but only after the judge ruled, and we had one more hearing in front of the new court, then, only then, and was Legato 2 filed, and it does allege a current taking. It does allege water currently over, and only after that, then did Legato start to argue that there was a current taking in this case. If you look, Judge Moriarty specifically said there was no argument in Legato 1 about current flooding or current overtopping of the ponds. And he said that in multiple of the transcripts at issue here. So in short, Legato said what it wanted. It got a definition of the rights so no one can take advantage of the property. The appellees ask that the court adopt the undisputed material facts identified by the district court in the journal entry, and especially because Legato 2 exists. While much of this case is moot, assistance in identifying and defining some of these issues will be very helpful to the district court and the parties as Legato 2 passes on. And therefore, we also ask that you apply the facts to the operative pleadings in Legato 1 and determine, as the district court did, that appellant has not made its prima facie case on counts 1, 3, 5, and 6, and that the counts in 4, 8, 9, 10, 12, and 13 are moot. We ask that you affirm so that the property and the owners of the property can move forward and make this productive property in Olathe. Thank you.
Seeing no more questions, Mr. Duggan, are we ready for your rebuttal?
Yes, Judge. Thank you. Just to pick up on what Ms. Greathouse just mentioned, to make this property productive in Olathe would mean to sell it to Woodbury under the current zoning and utilize all the plans that are in place. Otherwise, you got to go back to square zero, which we're okay with, saying that these plans are illegal and that you cannot use that rezoning ordinance. But no one wants to make that commitment. No one's ever wanted to make that commitment because we supplied the court with other newspaper articles. And that's the irony of this, is that we're going to decide a fact question based upon newspaper articles. But there is a recent newspaper article we put in the reply brief that says they want to go forward with the project as is. So we need a ruling, and we are concerned that they're going to do exactly what we suspect they're going to do, which is to publish that ordinance after this ruling comes down and say, now we're going to go forward with it. We need it invalidated. The second point Judge Schroeder pointed out, I think this is legitimate. Judge Moriarty said there's fact disputes about whether or not the city's properly maintaining these basin areas. Well, those same fact disputes are the same fact disputes that go to the unlawful physical taking of our property. We argued, showed photographic evidence that the rock walls are caving in because the water's gone beyond the boundaries of the easement, eroded the rock walls. Photographic evidence shows that. Photographic evidence shows that pollutants under the Federal Clean Water Act, mud, silt, and other debris are penetrating inside the boundaries of the easement. The very same fact disputes that substantiate our breach of contract claim are the exact same fact disputes that substantiate the unlawful taking. The city nor any other government entity can invade my property with their stormwater, their mud, their silt, their debris without being legally authorized to do so. And when you do that, that is a taking. And that is the argument we've been making to the lower court and to this court. It's not moot. There are fact disputes presently. Picking up on the other point, and this is important, why would we be arguing about whether or not a preliminary stormwater plan was relevant? We supplied record evidence to the Court of Appeals that shows that Michael Wilkes, the city manager, sent my client a hand-delivered letter that specifically represented that a preliminary stormwater plan was a prerequisite to a rezoning approval and that one had been completed. That's the very preliminary stormwater plan that shows my client's property being flooded 7 acres in a 100-year flood event. And the final stormwater plan doesn't modify that in any way. It was only after they lost the argument in front of Judge Moriarty, and the record runs counter to the representations of counsel today. They stood up in open court and said, more or less means we get to use whatever we need to use for stormwater discharge, up to 7 acres if necessary. We can flood you wherever we have to. That is what they said in open court. They lost that question. Then and only then did they come back to Judge Moriarty and say, we're working on a revised stormwater plan as we speak, Judge, based upon your ruling that we can't go beyond the boundaries of the 17.91 acres. That, in fact, took a little bit of effort by Judge Schroeder to get that commitment on the record today, that, in fact, that's what they now understand and agree we're going forward with. We want a simple opinion. 17.91, no more. No water beyond that, no mud beyond that, no nothing. The rezoning ordinance that was based upon this stormwater plan that said they're going to flood our property is illegal, can't be enforced. And if the city won't commit to saying it's been withdrawn, the court can say it's null and void and moot because it was based upon a stormwater plan that was illegal, i.e. 7 acres of our property. That both stormwater plans are moot, now can't be used because they're part of an illegal rezoning effort. Also, that the city has no right to discharge silt, mud, or any other debris inside the boundaries of the easement or outside the boundaries. The only thing they can do is discharge water through the easement boundaries, just as Judge Schroeder asked counsel. That means that when it rises and falls, it still can't go beyond the 17.91 acres of the meets and bounds legal description. And that's always been our agreement that we believe that we had with the city at all times. We also believe that they have no legal authority at all to cause any water to go beyond that, whether it's a 1-year flood event, a 10-year flood event, or a 100-year flood event. And the case should be remanded back for determination as to what our damages are for the cleanup under the count for breach of contract, but also for the illegal taking of sending the mud and the silt and the debris beyond the boundaries and the mud and silt within the boundaries, as well as our 1983 claim, because we're entitled to seek those remedies. As the judges all know, you might have 5 or 6 cases, legal theories that are all based upon the same set of facts. As long as they're not mutually exclusive, I get to pursue all those legal theories on one set of facts. And if in fact I choose at a later date to go breach a contract, unlawful taking, whatever I think as a lawyer or my client is the best chance to succeed, I can narrow it down at a later date. But you don't just throw them all out and say, well, I don't want the taking and I don't want the 1983 and I don't want this, but I'm going to let you go forward on the breach of contract because there's fact disputes about whether or not mud and water and silt are going beyond the boundaries of the easement and how much it's going to cost to clean it up. That same set of facts substantiates an unlawful taking, a 1983, the deck actions, and the breach of contract action. So we simply ask the court to reverse, clarify specific easement, nothing beyond the boundaries, and let us have our determination as to whether we've been damaged, if at all. They'll have their fair chance to say, you haven't been hurt. We should have our fair chance to say, here's what our damages are. Thank you so much for your time.
Let me ask you one follow-up question.
Yes.
Are you saying that when stormwater moves, my experience is that it carries with it whatever's mixed in the water? Are you saying that the easement that you granted in 1993 did not allow the city to discharge the stormwater as it moved onto the Legato land?
Well, I'm going to say this, and I'm going to be very candid. I lived on a farm, Judge, and when water moves on a farm, there's a lot of stuff in it, leaves, crop disbursements, and everything else. When you're inside the city limits of the city of Olathe, and everything is controlled by a national discharge pollution requirements in the EPA, you cannot discharge debris in water inside the city. And when we granted them a easement, it had to comply with all relevant laws, including their own ordinances and EPA and Clean Water Act requirements. So no, you don't get to discharge debris in the water that ultimately settles to the bottom of our pond and results in a pollutant being on our property. This is a requirement of the Clean Water Act. Olathe is very familiar with it. They enforce it routinely. And what I'm saying is, no, they do not have the right, nor does anybody in the state of Kansas, as a matter of law, have the right to discharge oil, water, pollutants, which includes mud, silt, and debris in stormwater pipes. That's the law under the Clean Water Act. I'm happy to answer any more questions, and I thank you so much for your time and attention to this matter.
I have none.
Seeing no other questions, we will close as far as the arguments on this appeal. Before we do close, we appreciate the arguments that were made by the parties today. We will take those arguments under consideration and issue opinion as soon as we can. This court is adjourned until May 13th at 2 p.m. We thank you very much.